Greetings, everybody. It's Monday, it's 6 p.m., and that means it's time for Shihab Burke to be here live on YouTube. Specifically, me, attorney Brian Burke of Shihab Burke, just like it says below. Every Monday and Wednesday, 6 o'clock, either me, my partner Sam, or more likely both of us, comes here to talk to you guys about an immigration issue that we find interesting and near and dear to our heart. And today, that topic for me is employment-based interview prep. One of my favorite things to do as an immigration attorney is to go with people to green card interviews. I'm jealous of my attorney colleague Joe Morhart. He was just traveling late last week to go to one, and I'm itching to get them to my next chance to go to a green card interview. And I think what I want to do today is sort of go through how I help somebody to prepare for an employment-based green card interview, because it's a topic that I love. It's a topic that is sort of, I don't know, metal to metal for an immigration attorney. You know, going to that government office, dealing with the government officer, dealing with that client, helping them through that once-in-a-lifetime important interview, something I absolutely love. So what we're talking about is employment-based green card interviews, and I'm going to walk you guys through, you know, what the process looks like. So obviously, the first thing to know is you get your interview notice. The interview notice you get from USCIS, odds are it's going to be a very generic one. It's going to be an interview notice of the sort that they hand to marriage-based cases, employment-based cases, all other types of green cards that you might apply for. Typically, they all get the same Form I-485 interview notice. So I guess the first thing you should understand is not everything on that interview notice is going to be relevant to you. But the most important thing I'd say, where to start, is understand when and where the interview is. Duh. But as an attorney who understands that people sometimes miss these interviews, I'd say the most important thing to take away from the interview notice is be there at the right place at the right time and plan for it. I would suggest driving by beforehand, figuring out where parking is, and considering that it's going to take some time to get through security at USCIS, because you do not want to walk in there late, because if you are not there when you're supposed to be, they will cancel your interview and they will deny your green card case. I have done plenty of appeals for people who have, oops, not appeared for their interview, and it's not a pleasant thing. So basically, do reconnaissance. Figure out where you need to be a week before your interview, 2 weeks before your interview. Travel by to the area, figure out where you need to go, because that is so important. If you're an anxiety-driven person like me, if you want to make sure things are done right, you plan for it. You do it once before to make sure that when it's time to do it live, you do it right. You get there timely. There you go. Me, I always try to arrive an hour beforehand. Why? Because, man, it's important. As an attorney, I would never want to miss your interview, and you sure as heck wouldn't want to miss yours either. Maybe let's talk about attire. You know, I've been to plenty of USCIS waiting rooms, and I sometimes see people in there, you know, they are dressed out there in their street clothes. And darn it, I gotta recommend against that. You know, you are applying to immigrate to the United States, and sooner or later, that officer has to sit down and think about your case and say what kind of decision they want to make. Now, they're not supposed to make decisions based upon your appearance, based upon, you know, what's said on your shirt that day, you know, based upon whether or not, you know, your hair looks clean. But you should want to be the person who really kind of looks good, looks like the sort of person for whom they want to approve a case. Because, you know, they're not supposed to act upon things like that, but they are human beings. They have biases. When I tell my clients that when that officer comes and thinks back at your case, you know, later when they're ready to make a decision, I want them to think, that person was sort of respectful to the process, very nice, very well put together, professional, you know? Professional attire is typically what I recommend. You don't have to go sort of full suit. I don't think anybody would blame me if you went for full professional attire, but, you know, I usually tell people you want to look like you're going to a job interview is a good standard for USCIS interview. Talk about generally getting there. Make sure you have what you need to get into the office. You're going to need that interview notice. You're going to need your identification, and that's that. And one of the things that a lot of people are concerned about, and I'm going to maybe cover it for everybody right now, is what do you do when you get there? So every time you go to a USCIS interview, it's in a federal building of some sort. It's a high security place. You're going to find security that is comparable to an airport, meaning there's going to be a big old team of security folks there, and they're going to make you take off your belt. They're going to put you through a metal detector, you know, put your stuff through a metal detector, etc. So understand that, you know, you are going to be placed under security scrutiny. But once you get through security, usually the folks at security are very nice, and they'll tell you where to go, and you'll say something along the lines of, hey, I'm here for a green card interview, they'll tell you where you need to go in the office. If it's a big federal building, they might tell you, go up an elevator. If it's a smaller regional office, they might tell you, you might already be in the waiting room where you're supposed to be. Generally speaking now, most USCIS offices have a check-in system where you'll go and check in the window, and they'll hand you a receipt that says, you're A12, B4, and that's your number to check in for an interview. And once you have that number, you're checked in, you'll be waiting in a waiting room, and you're going to be waiting for an officer to call your number, B12, C14, whatever they give you. That's going to be that's what you're waiting to hear when you're in that waiting room. So it's worth also talking about the people who are interviewing you. The people who are interviewing you are not, ICE. They're not Customs and Border Protection. Generally, they are civil servants. The place where they're going to interview you is an office not unlike mine in this office here. A big wraparound desk, a couple of chairs in front of them, and the place where you're going to be interviewed is the place where the officer does their day-to-day work. You're going to see pictures of their families on the wall. You're going to see pictures of the other files. You're going to see the other files they're working on the back desk. It's really a sort of informal office. You're not in an interrogation room, so that's worth knowing. Talk about documents to bring. So I know when we put an I-485 case at the door, we include everything that we think that is necessary for them to be successful. And if you read through that interview notice, basically that's kind of what they asked for. But I'll tell you generally what I would recommend somebody brings. Passport with your entry stamps, all your passports with your entry stamps and visas, your birth certificate, your marriage certificate, medical exams if they're expired, and if you're an employment-based case, and I would always recommend a fresh supplement J. That's even if you've changed jobs or you haven't changed jobs, because I've been at plenty of interviews before for employment-based green cards, and a lot of officers now say, hey, where's your supplement J? Legally, probably, if you're still with your same employer, you may not think you need one, but there's two options. You can argue with an officer whether or not a new supplement J is required because I'm still with the company, or you can just give them a new supplement J, make an officer happy, and that's always what I am going to do. Things they might ask about elsewise are educational credentials, W-2s, that sort of thing. I would encourage you to be, over-prepared. Why? Because there's nothing wrong with that. The worst case is you do a bunch of work and you don't need it. But I would also encourage you to not bring things to a USCIS office that you don't want them to see, because just sort of presume that everything you have on you could, in theory, be inspected by a government officer whilst you're there. You want to be organized, because I wouldn't want you to actually, I don't know, want to hand them a W-2 and accidentally hand them something, you don't want them to see. My general advice is create a separate folder, a separate carrying case for all the documents you want to bring in this interview so you don't get surprised by anything that's in there, essentially. So when you get to the substance of the interview, the first thing I would tell you is that when it comes to a USCIS I-485 interview, and this applies to family-based or employment-based, is that I can predict what the very first question that is going to be on the form with a probably 90% accuracy. It's going to be, or not the first question on the form, but the first question asked of you. It's going to be, what is your first name? Then it's going to be, what is your date of birth? And it's going to be, where were you born? How do I know this? Because those are the first 3 or 4 questions on Form I-485. What you should understand about the green card interview is that a lot of the time spent during this interview is going through your forms, going through your I-485, and having the officer verify that the information that's in there is accurate, because it's part of their obligation to basically say, oh, if you change employer, got to update the records. Oh, do you accidentally say no to a question like that you meant to say yes to? Got to update that. So a major portion of the interview is this officer is going to go through the I-485 form. They're going to confirm your personal biographical information, what's your name? Where were you born? Who are your parents? Who do you work for? Where do you live? They're going to go through all those things. They're also typically going to go through all those fun security questions at the back of the form. For those of you who have filed I-485, on the back half of the form is about, I think it's maybe like between 60 and 80 questions about various immigration compliance issues. Have you ever violated the terms and conditions of your status? Have you ever worked without authorization? Have you ever committed any crimes? Have you ever been denied a visa? Are you a terrorist? Have you ever been involved in prostitution? All sorts of things like that. They're going to ask you those questions once again. Even though you already said yes or no to them as applicable, as part of signing off on the form. Part of their job, a major portion of your I-45 interview, is to go through those questions again and make sure the information they have is accurate. And a big sort of thing that surprises people is what they're going to have you do is they're going to have you sign off and say, yep, I gave you accurate updates to all this information. So essentially, they're double checking on your forms for a lot of the interview. But for employment-based interviews, once they go through the content of the forms, if they're interviewing you, there's probably something they want to ask you about substantively. Well, I guess I would say that's true historically. Right now, we're in a climate where we suspect most people are going to get interviewed for I-485. But I think your safe bet is to presume there's a specific reason why they want to interview you. And maybe we'll talk about some of the things they want to ask you about, that they might ask you about, that we sort of see people get asked about. Let's see. If you've attended school in the United States, they might be interested in your time as a student. I've been to plenty of interviews where the officers really focus in about your compliance as a student when you were on student visa. That's sort of that. So what they might be thinking about is like, have you ever worked without authorization? Were there ever times when you were on OPT or STEM OPT where you didn't meet your employment obligation requirements? That sort of thing. Those are sort of the most common ones. The common ways that people can screw up their F1 status, and thereby sort of the most common things that people, USCIS rather, will ask about. When it comes to your H-1B history, they'll really what their sort of favorite thing to do is ask you about your employment history, especially if you're in the world of IT consulting. In the world of IT consulting, you might have an employer, and they might assign you to client A, and then that client project ends, they assign you to client B, and then client C. I have experienced many interviews where USCIS is worried that you've had large swaths of time where you either aren't properly employed, you're not doing the work you're supposed to be doing. If you're a software developer, you're not developing software. If you're a systems analyst, you're not analyzing systems. If you're an accountant, you're not accounting, So they can basically ask, were there any periods of time when you weren't really, working for your employer? That's the sort of thing. They also might consider whether you're being paid appropriately. For people who have a history on H-1B visa, it's, you guys know that where you're working is the physical location where you're working can determine whether or not you're in compliance. Your H-1B visa petition has an LCA in it. The LCA determines, where you're supposed to be working, what you're supposed to be paid. And if they find, nobody filed an amendment for your H-1B timely, those things can be an issue, and they've really had them dig down into your H-1B history as well. Speaking about that, there's a spot where they have a great spot to sort of compare your working history as it's been stated in the past. A sort of more popular trend in maybe the last 2 or 3 years is to look deep at your labor certification case. If you're an employment-based immigrant and you have a labor certification-based I-140, we have been getting, questions about the offered job on your labor certification, and really some of the employment history as listed on your labor certification. And legitimate questions they can ask are, is this job that's set forth in this labor certification really sort of still available and viable? So that's sort of that as a really important issue. Now, I guess maybe sort of going through everything I just said so far, there's a question of, well, Brian, how do I prepare for that? My number one advice, if you forget everything else I've said during these last 15 minutes or so, is review your file. If you review, you are an expert in you. If you go back and review your immigration records, review your H-1B history, review your I-45, review your labor certification case, review your I-140. If you look at those things and you see things that aren't right, it's reasonable to suspect that a U.S. government officer might see them as well, and they might ask you questions about potential inconsistencies there. And knowing what those things are before your interview and discussing them and figuring them out is really a way you can prepare yourself for an interview. Now, maybe I want to close up on talking about what happens if something unexpected happens. Fundamentally, no lawyer can predict, no lawyer, and not you either, can predict exactly what is going to be asked during this interview. sometimes, this is the U.S. government we're talking about. It's the most powerful and most powerful government in the world. And, the running joke is they know what you ate for breakfast. And they might know something that could potentially be a problem in your past that you might not have even thought of. So they could ask you some, and I've been there for them, some very sort of interesting questions. And I sort of have to give my sort of, baseline advice on this thing. Give them honest answers to the extent that you can be honest. If they ask you a hard question and you have a good answer to it, you can give them a good and honest answer for it. I've come to people have come to me rather, and I've told them, the thing you were untruthful about. They come to me after an interview saying, Brian, I have a problem because I was untruthful about X, Y, Z. And I tell them, the thing that you were untruthful about wouldn't have been a problem, but the much bigger problem right now is that you were untruthful about the fact it's in and of itself, and that makes my job infinitely harder, probably even impossible. The other thing that sort of comes up is, obviously talking, you always got to tell the truth. That's my number one baseline advice, tell the truth too. But sometimes, especially in employment-based cases, I've been in scenarios where they want to bring somebody in for an interview and also want to get a written statement for them. And I have had USCIS officers, in the middle of a conversation with my client, start transcribing the conversation, typing in the questions and answers into a form so my client can sign off on it. You do not have to sign anything that is not accurate. I have had officers hand my client the most ridiculous things that don't reflect what come out of my client's mouth. And part of being successful at an interview like that is to go through what they hand you. If they want you to sign off something that's not accurate, you shouldn't do it because, fun fact, you're going to be swearing to the truth and accuracy. And if you swear to one thing that you say is true and they have evidence otherwise, that's going to be a bad time for you. So I have probably gone beyond the usual time we talk about the substantive issue, but interview preparation is something that I'm super passionate about. I think it's really super important for anybody who has a USCIS interview, which is going to be more people, to understand what to expect and how to prepare for it. Now what I'm going to do is what we always do here, back half of this presentation, I'm going to hit up questions. There's sort of two sources of questions we take here. One is going to be the live questions that anybody has put in the chat there, obviously on a delay, of course. And second, there are going to be the questions through our website, immigrationquestions.us. Immigrationquestions.us is our firm's website for taking any sort of immigration questions that you have during the week. That's immigrationquestions.us. But who cares about that? I'm going to take some questions what we have live here. Here's one from Venkat, and I'm going to put it up live in front of everybody so we can all bask in it together. So, from Venkat, will it be considered as a conviction by USCIS for immigration purposes if my defense lawyer gets an initial charge reduced to a traffic infraction, and what is the impact of the case resulting on the existing green card application? Well, it looks like I missed a couple prior questions, which I'll go back for, but and maybe I need the first part of Venkat's question here. I've been charged for a violation of move over law, reckless driving criminal charge in VA, and hired a defense attorney to represent me in district court. And it will be considered conviction for U.S. immigration purposes if my defense lawyer gets initial charge reduced to traffic infraction, and what is the impact of the case result on existing green card application? So these things, Venkat, are very fact specific. In certain states, there's certain plea agreements that can be taken that require you to sort of admit to the facts of the actual crime, but we're going to actually charge you with a lower one. And an admission in the right context can be problematic as the actual charge for immigration purposes. So I think that's the sort of question you probably need to seek out specific immigration counsel for help on. But usually, to give you a sort of maybe a more general answer, usually they will go by what you actually pled to. But again, the devil's in the details as to how you get from point A, the initial charge, to point B, what they actually convict you of in that state court. Because the short answer is, just because something is not a conviction for the purposes of that state court, it might be considered a conviction for immigration purposes, and that's sort of what Venkat is hitting at. And the answer is, I don't think in this venue, Venkat, I can give you a clear enough answer to that, something that you can really rely upon. So I missed one from PNT here, the first one. Can we reapply for another H-4 EAD while the existing H-4 EAD is in process, bundled with H-1B job change, award dress change in premium? So here's the beautiful thing about a scenario like this, P&T. Well, it really kind of depends. I'm going to imagine, there's an H-4 EAD out there that was filed before this new H-4 and EAD are filing, of course. So there's sort of two. I'm going to tell you anecdotally what I've seen. My conservative recommendation for anybody who wants to maintain employment authorization is to file that second H-4 EAD, because there's a reasonable chance that USCIS, in adjudicating that first H-4 and EAD, is not going to look to the fact that you have another case pending and give you an extension beyond what they approve you at a given time. But I have had, a scenario where somebody has a pending H-4 EAD, right? And then they, through a little bit of immigration magic, they travel and get a longer I-94, and they get the H-4 EAD gets aligned to that longer I-94. Maybe the best way to approach something like this, P&T, is think about what the risks are. The central risks are that the government takes your money and they don't give you a benefit. And ultimately, the risk of that is, what is it? $520 plus $520 is really the cost of an EAD filing. There's sort of a longer conversation to be had about that, maybe some more details to understand, but realistically, I sort of think about what are your risks, because there's likelihood of success, that's the one question, but what are your risks? And the answer is money's on the line. Money's important, but money's not everything. And there you go. Yeah. So let's see here. Chandrakant, hello, sir. Any chances of filing dates moving past August 2013 for EB3 India for October 2025 visa bulletin? Well, boy, everybody, it is September. It is already a week into September, and it is an appropriate time to think about the most important visa bulletin of the year, the October visa bulletin. Why is the October visa bulletin the most important visa bulletin of the year? It's the most important visa bulletin any year because that's when the government fiscal year begins. That's when a new swath of visas becomes available, and the government takes that into account and moves dates. So generally speaking, you see big movement on visa bulletins in the month of October. Now, I think it's a bit early and premature for the October visa bulletin to come out this week, but you never know for next week. Next week is the week of the 15th. That's a time where I think you might actually see one. Then again, they sometimes release them on Fridays. I guess I'm not going to predict the rate of release on them, but let's see here. August 2013, EB3 India. So we are on September 2025 right now. August 2013 is what is being asked about for final action. He's looking for filing dates. Filing dates for India, EB3, they're on 8th of June 2013, and this is somebody trying to get it past August of 2013. I don't think it's so crazy. Here's what I'll tell you, Chandrakant. I don't think myself nor my partner Sam is very much into predicting the visa bulletin because it is unpredictable. It is in theory based upon data, but also, I can only imagine there's a sort of touch and feel involved in how it is moved as well. I think it is somewhat of a political animal. But here's the bottom line. I would say, if you told me that we got into August 2013 EB3 India on the visa bulletin for October 2025, that would not surprise me at all. And that's sort of how I evaluate things. Would I be surprised? No. You're kind of right on the realm of what I think would be normal, wouldn't blow my mind. All I can say is, Chandrakant, neither you or I control when it gets there. We'll just cross our fingers for you for the month of October, and ultimately not even for the month of October, for the late month of September when that visa bulletin comes out. So, hi Brian from Hari Guru. On a few forms, my father's first name has both words without space, and a few has one space. Does it create any problem with my pending adjustment of status? Example, education certificate and non-available birth certificate got no space, but affidavits has. So, welcome to the world of Brian Burke, the immigration attorney, Hari Guru. When I'm reviewing forms, we try to catch these things as much as we can, but nobody is going to be perfect. And that's, there's a legitimate question, Hari, as to whether, what is the true version of your father's name. But this falls into an issue that I would call immaterial. One that they shouldn't be bothered by about, because fundamentally your eligibility for a green card does not really hinge upon whether there's a space in your father's name or there isn't. And you know, I've had conversations about issues like with people before, and I would say, is there any way they could think that, you know, Hari Guru was trying to be dishonest or creating a problem by doing this? It seems very, 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 very unlikely. I haven't seen all the details, but based upon the way you're describing it, it really sounds kind of minor and immaterial, where any reasonable person can look at this and say, oh, one spot it says, you know, I don't know, Ramakrishna, you know, no space, and the other one says Rama space Krishna space. It's the sort of thing where everybody it'd be patently clear that it's the same person, and that's that. Obviously, I would always encourage everybody to be as accurate on the forms as possible. For example, if I'm reviewing a set of I-45 forms, which I was just doing before I walked in to do this talk, you know, if they have a field on the form, and they do, that states, you know, multiple spellings of, you know, any alternative names, you know, if you know, maybe the legal name as it's recorded in official documents is Ramakrishna, no spaces, and, you know, but sometimes it says Ramakrishna, it never hurts to disclose these things. But it's just not the sort of thing that I would lose sleep over, Hari Guru. That is for sure. Okay. I'm gonna try to get all the questions I have here live. I have one more, but I want to get to those fun immigrationquestions.us questions that we have here, because that's just something we like to do. So we have a couple. Let me see here. The last time Sam and I were in here was on the 3rd, and I'm gonna make sure we try to get these 3 that are in here. Let me see here. So a question from another Hari. When we apply to a birth certificate RFE, do we need to send the originals of the Form 10 non-available certificates and RFE letters from your USCIS or photocopies? So generally speaking, USCIS asks for originals when they want them. And very rarely do they ask for originals. I haven't seen the text of an RFE, but presume anytime you send an original to USCIS that you will never see it again. Generally speaking, USCIS, if they want to see originals, as I mentioned earlier in this, you can bring birth records to your interview. And there you go. So generally speaking, it's been a long time since I've seen a request for them from USCIS in an RFE, but typically they will ask for originals only if they really, you know, want them. And they will make it pretty clear to you that they're actually looking for originals. Let's see here. Here's a question here from, I'm going to try to put it up in front of everybody, from, well, Scarlatti. And I'm going to put it up here so we all can see it. Here we are. I'm on H-1B, and my wife is on H-4 with her EAD. Her license had issues, which she fixed, but she can't sign up for Uber driver. Can I sign up for her in my name so she would be the one driving? Will it create an issue for me when I adjust status? So there is, you know, my answer is I would strongly recommend against that, excuse me, and I'll tell you why. So sooner or later, that Uber driving is going to generate a 1099 in the primary person's name, right? And they're going to send that to you, and you're supposed to pay taxes based upon that. And if a government officer sees a 1099 in your name from a company, I think you're going to be facing an absolutely terrible uphill battle that says where they're going to say, baloney, you're the one working. Oh, no, 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 it was actually my wife working. She was using my... that's not a situation I ever want to put somebody in. I would be concerned about that. You know, I would tell you, generally speaking, that USCIS doesn't look into too much detail in your taxes, but you're just playing with fire by considering to do something like that. Because all it takes is for you to be the one case where they look at these things and suddenly you have an issue you can't fix, essentially, you know? And one more thing, one more question here from immigrationquestions.us. This is probably beyond the scope of what we can answer here sort of thoroughly as required, but I'm going to try my best to answer it for you and give you a little bit of information, some of the things to think about. I have 12 days of unauthorized work while on H-1B driving for Lyft. Does INA 245K apply to an EB-2 natural interest waiver, and how should I go about disclosing this in the interview? What will the officer do? So I think very first and foremost is for you, so let me maybe sort of take a step back. INA 245K is a provision that sort of forgives up to 180 days of a violation of status, work without authorization, or overstay in terms of an employment-based green card application. Now, really understanding how that works and applies to your situation is probably beyond the scope of this conversation. So, but generally, INA 245K applies. You know, the INA 245K is for employment-based green cards, like your EB-2 national interest waiver. Now, disclosing at this interview, my answer would be carefully. And because, well, as an aside, your interview should not be the first time this is disclosed. Why? Because you were already asked this question on Form I-485. You would have been asked whether you've ever worked in the United States without authorization. And I presume, okay, I'm presuming this happened before you filed the I-485. If it happened after, that's another conversation there. But basically, the short answer is we have represented many clients coming to USCIS interviews with INA 245K issues. And basically, the answer is we will typically either go with the client or hand them a letter that sort of explains, hey, yes, I'm giving you the best information I have. That is, yep, I broke the immigration rules technically, but you don't have to deny my green card because INA 245K protects me. But the major part of that is really kind of doing the analysis to make sure that INA 245K does protect you, and that's the thing that would really worry me. And there's a big analysis there as to when the violation occurred and does INA 245K protect you. I mean, one of the rules is that INA 245K doesn't basically wipes clean the slate during prior visits to the country. But an inevitable question is, well, have you ever been asked about this before? Because if you were untruthful about this before and you haven't brought it up, a problem you're going to have is that, well, fine, INA 245K would have protected you, but in order to get protected by INA 245K, you were untruthful somewhere else. And that, I guess, does INA 245K apply is a pretty darn complex question. So there's one live question here. I did start a little bit late, so I'm going to try my best to answer it for the benefit of MG here, who has asked the question. Does EB-1 rest of the world spillover from the current war family-based visa spillover get factored in October or later? Does EB-1 rest of the world spillovers from last year go into India first as the most backlogged country? So I will answer the second question first because that's the one I am far more sure of. Visas availability, rollover visas, extra visas available, unused visas go to the most backlogged country first. So in the EB-1 category, that's going to be EB-1 India, because if I look at the September 2025 visa bulletin, EB-1 India is, drumroll, in final action dates of February 2022, whereas its nearest neighbor, EB-1 China, is in November 2022. Now, when they factor in that spillover is beyond me. One of the things that sort of sticks in my head, MG, about the visa bulletin and they talk about visa availability is that sometimes it's a while before USCIS, or rather the Department of State, excuse me, announces visa availability for the next fiscal year. And I can't help but think, considering that they are issuing visas up until the absolute last minute of, fiscal year 2025, I presume that they don't have very good information on day one of fiscal year 2026. So I guess my short answer is I don't think it's possible, because they should be issuing family-based visas up until the very end, essentially. So it is 6:34. I've talked myself pretty hoarse, but I got my water right here, so I'm going to enjoy a sip of that. I'm going to thank you guys all for tuning in. And I'm going to see you again Wednesday, 6 o'clock p.m. Thank you all.